So have you ever really thought about how France works? Like, what's the instruction manual for the country? Well, it all comes down to its constitution. You can think of it as the political operating system for the whole nation. And it's a fascinating document that shapes everything from presidential power to citizen rights. And we're about to break it all down.
Which brings us to the big question, right? Who is really in charge in France? Is it the president, the prime minister, maybe the people themselves? Well, the answer is a little more complicated and honestly, way more interesting than you might think. And it's all spelled out in that constitutional rulebook.
All right, so here's our game plan. We'll start with its really unique hybrid design, then we'll dig into the Republic's core principles and meet the powerful duo running the executive branch. After that, we'll see where Parliament and the people fit in, discover the Constitution's ultimate guardian, and finally, see how this rulebook is a truly living, breathing document.
Okay, first up, the foundational design. We're talking about the Constitution of the Fifth Republic, which was established back in 1958. Its whole purpose was to create a strong, stable executive after years of political instability, and the result was a political structure you really don't see anywhere else.
At its heart is what experts call a hybrid, or a semi-presidential system. And this creates this really fascinating built-in tension. You have a powerful president chosen directly by the people, and at the same time, you have a prime minister who absolutely needs the support of the elected parliament to function. It's a constant balancing act, designed right into the core of the government.
So, what ideas underpin this whole structure? Let's get into the philosophical soul of the French Republic, the principles that give the entire Constitution its meaning.
You know, the core identity of the Republic is laid out right there in the very first article. These 4 words, indivisible, secular, democratic, and social, are the absolute pillars of the French state. And believe me, they aren't just words on a page. They guide legal interpretation and political debate to this very day.
But here's the crucial point. The French Constitution isn't just the text from 1958. There's actually a wider collection of foundational texts that all have constitutional authority, known as the bloc de constitutionnalité. This bloc, the full constitutional rulebook, weaves together centuries of French history and values. It includes the revolutionary 1789 Declaration of the Rights of Man, the social and economic rights from the 1946 preamble, and even a 2005 Charter for the Environment. All these different texts are used by judges to make sure new laws respect France's fundamental principles.
Okay, now let's look at the executive branch, which is defined by a unique and powerful duo at the top, the president and the prime minister.
You can see the distinct roles here, the president as the head of state and the prime minister as the head of government. But here's the key takeaway from their relationship. The president holds the power to appoint the prime minister, but that prime minister is totally powerless without the support of parliament. This creates a fascinating power dynamic at the very top.
But the French government has a very special and very controversial tool in its constitutional toolkit. You could almost call it a legislative superpower.
I'm not kidding. Imagine this, the ability to pass a law without getting a direct yes or no vote from the primary house of parliament. It sounds extreme, but it's written right into the Constitution.
It's called Article 49.3. And here's how it works. The government can stake its own survival on a piece of legislation. The bill is then considered passed unless the National Assembly successfully votes to fire the government with a motion of censure. It's a high-stakes maneuver that basically trades a vote on the law for a vote on the government itself.
So with such a powerful executive, where do the people and their elected representatives fit in? Well, the Constitution is very clear on where ultimate authority truly lies.
Article 3 states that sovereignty belongs to the people, full stop, and they exercise this power in 2 ways. Indirectly, through their elected representatives in Parliament, and directly through referendums.
Now, Parliament itself is made up of 2 houses. You have the Senate, which represents France's territories, and then the National Assembly, which is the dominant chamber. It's the National Assembly that ultimately passes laws and, as we just saw, holds the power to dismiss the government.
Okay, but who makes sure everyone, the president, the government, and parliament, plays by the constitutional rules? That job falls to a special body, the Constitutional Council. And a major 2008 reform gave this guardian a revolutionary new tool that directly empowers citizens. It's called the Question Prioritaire de Constitutionnalité, or QPC, and it gives any person the power to challenge the constitutionality of a law being used against them.
The process is pretty straightforward.
During any court case, a citizen can argue that the law being applied to them violates a fundamental right. If the lower courts agree the question is serious, it gets sent all the way up to the Constitutional Council, which then makes a final ruling. This has massively expanded the Council's oversight.
This brings us to our final point. The French Constitution isn't some dusty document set in stone. It has been amended dozens of times, making it a living rulebook that adapts to the times.
Article 89 lays out two main paths for revision. An amendment can be put directly to the people in a national referendum, or it can be approved by a special 3/5 majority vote of both houses of Parliament meeting together in what's called a Congress.
And this flexibility has led to some major changes over the years. In 1962, a referendum established the direct election of the president, which hugely boosted the office's legitimacy. In 2000, the presidential term was cut from 7 years down to 5. And, as we just discussed, the 2008 reforms created the QPC, giving citizens a powerful new voice in the legal system.
So, from its unique hybrid design to its capacity for change, the French Constitution is a truly dynamic framework. This leaves us with a final, crucial question. As France navigates all kinds of new challenges, from social unrest to European integration, how will its 60-year-old rulebook adapt next?